This year, apart from marking the 200th anniversary of the Supreme Court, marks the 50th anniversary of the passage of the Trade Practices Act, a piece of Commonwealth legislation. This transformative consumer protection statute contained a provision, section 52, that proscribed conduct that is misleading or deceptive or is likely to mislead or deceive. Critically, for present purposes, that statute is not directed solely towards intentionally deceptive conduct, but operates at an objective level. In other words, if a statement or representation or conduct is inconsistent with the objective truth such that it is misleading or deceptive, the courts will impose a remedy. To borrow the language of legislation currently before the Federal Parliament, that Act is concerned not just with disinformation. Now, disinformation is deliberately false information, but also with misinformation, that is objectively false information.
Well, ladies and gentlemen, good evening and a very warm welcome to the Centre for Independent Studies. It's a pleasure for me to welcome you this evening and to our 21st Acton Lecture. I'm Peter Curtie, a research fellow at the Centre for Independent Studies, and I coordinate the Culture, Prosperity and Civil Society programme within which the Acton Lecture is held. This year we are particularly honoured that the Chief Justice of New South Wales, the Honourable Andrew Bell, has agreed to be our Acton Lecturer. The Acton Lecture offers a platform for prominent individuals to offer their own reflections on contemporary issues of culture, faith, and society as they arise in and confront contemporary Australia. The issue with which this year's Acton Lecture will engage is truth, and the challenges presented by shifting conceptions of truth, especially in the administration of justice. The courts, of course, are concerned with the kind of truth that has an evidentiary basis, tested by the adversarial system. Pursuit of this kind of truth is qualified by considerations such as the exclusionary rule of evidence and is highly specific to a question brought to the court by the parties. Even so, taking a matter to court is an exercise fraught with risk and one in which the pursuit of victory often seems to take primary place over the pursuit of truth, where justice is only weakened by employing, as it were, a stronger knave to frustrate a weaker. In George Eliot's Mill on the Floss, the determinedly litigious but strictly honest Mr. Tulliver said that law should be thought of as a sort of cockfight in which it was the business of injured honesty to get a game bird with the best pluck and the strongest spurs. What might Mr. Tulliver have made of today's postmodern notions of truth, which are frequently subjective, that depend upon feelings and are shaped by claims about lived experience? And what is the impact of these postmodern notions of truth on the task faced by a judge? How do we come to terms with the idea of the decay of truth, with changing conceptions of honesty? And how will all this affect the administration of justice? Well, these are the questions with which this year's Acton Lecture is concerned. And so to our lecturer himself. The Honourable Andrew Bell was a double university medalist in arts and law at the University of Sydney and also won the University Convocation Medal. He won a Rhodes Scholarship to the University of Oxford in 1990, where he read both for the degree of Bachelor of Civil Law, the BCL, winning the Vinerian Scholarship, and for a doctorate there in private international law. Returning to Australia, his honour was called to the bar in 1995, took silk in 2006, and was then appointed from the bar to be President of the Court of Appeal in 2019. He was appointed as the 18th Chief Justice of New South Wales in 2022. An avid cricket fan, his honour was also for a long time chair of Sculpture by the Sea. One of the first things he remarked on when arriving tonight was the sculpture on the wall that is called Joining the Dots, that we've had for a number of years here. It took his honour's attention immediately. Well, I'm delighted that His Honour has accepted the invitation to deliver the Centre for Independent Studies Acton Lecture for 2024, and I invite you to welcome him now.
Well, thank you, Peter, and good evening, everyone, including a number of friends I see in the audience who I'm delighted to see. It's a pleasure and an honour to have been asked to deliver the Acton Lecture, revived, I think, after a hiatus of a number of years occasioned by COVID, and I thank my friend, the Reverend Peter Curti, for his kind invitation to do so. As some of you may be aware, this year marks the bicentenary of the Supreme Court of New South Wales, making it one of the oldest continuing common law courts in the world, and it held its first sitting in May 1824. That was some 10 years prior to Lord Atkin's birth, and it's his great scholarship and values that this lecture honours. Lord Acton, with his indelible commitment to liberty, would have approved strongly of our first Chief Justice, Sir Francis Forbes. Under the Third Charter of Justice, which established the Supreme Court and also an incipient version of the Legislative Council of New South Wales, the Chief Justice was required to certify that any law of the colony passed by or recommended by the Legislative Council to the Governor was not repugnant to the law of England, including the common law. In other words, the first Chief Justice had a right of veto on the legislature, a right which doesn't entirely continue to exist. But in 1827, Governor Darling was agitated by adverse press coverage of his actions, particularly adverse press coverage in a journal called The Monitor and also another journal called The Australian, then under different ownership. The Governor introduced legislation into the Legislative Council that required newspapers to be licensed and to pay stamp duty on each issue. Chief Justice Forbes refused to certify that this law was consistent with, or putting it the other way around, he found that it was repugnant to the laws of England, quoting both Blackstone and Lord Ellenborough, and said, and I quote, "The right of printing and publishing belongs of common right to all His Majesty's subjects and may be freely exercised like any other lawful trade or occupation. So far as it becomes an instrument of communicating intelligence and expressing opinion, it is considered a constitutional right and is now too well established to admit of question that it is one of the privileges of a British subject to subject the press to the restrictive power of a licensor, as was formerly done, both before and since the Revolution," this is 1827, "is to subject all freedom of sentiment to the prejudices of one man and to make him the arbitrary and infallible judge of all controverted points in learning, religion and government. The right of licensing under the proposed law would rest solely with the then Governor." Continuing, Forbes said, "Indeed, to admit the power of selection among publishers would be more repugnant to the spirit of the law than to impose a direct imprimatur. It would not be merely to confine the right of publishing within partial bounds, but it would be to establish a monopoly in favour of particular principles and opinions, to destroy the press as the privilege of the subject, and to preserve it only as an instrument of government. By the proposed bill, the right is confined to such persons only as the Governor may deem proper. By the laws of England, the liberty of the press is regarded as a constitutional privilege, which liberty consists in exemption from previous restraint. By the proposed bill, a preliminary licence is required, which is to destroy the freedom of the press and to place it at the discretion of the government." And then, in considering an argument that such legislation should be justified as a matter of practical necessity, the Chief Justice said in an amusing passage that the press of this colony is licentious may be readily admitted, but that does not prove the necessity of altering the laws. So Forbes's commitment to freedom of the press was not to deny the availability of actions of libel and slander, the written and verbal variations of what we now know generally as the law of defamation. In the law of defamation, truth has not always been a defence, at least in cases of criminal libel. So you could be defamed by someone who uttered a true statement. In areas of civil libel in New South Wales, for many years since 1847, truth was only a partial defence in the publication of true but defamatory matter. It also had to be shown that the publication of the true but defamatory matter was in the public interest. That was an interesting law because it related to the causes and the concerns of the emancipists, many of whom had a background of which they were understandably not proud, but who had served their term, become liberated, and gone on to play a significant role in the nascent colony. So if they were defamed by something which was true about their past, if the publication wasn't in the public interest, truth was not a sufficient defence to the person who defamed them. Under the modern and uniform law of defamation in Australia, however, what's known as substantial truth is now a defence to the publication of defamatory matter if the defendant proves that the defamatory imputations carried by the publication are substantially true. The law of defamation, therefore, is an area in which the courts are expressly tasked with ascertaining the truth, or at least what is referred to in the legislation as the substantial truth, when this defence is raised. In this lecture, I propose to explore the extent to which the courts are concerned with the ascertainment of the truth more generally, some limits on their ability to do so, and the implications of what some scholars have identified as, quote, truth decay for the work of the courts and respect for the third arm of government. Now, the arresting and alarming phrase truth decay is associated with the 2018 publication Truth, Decay, an Initial Exploration of the Diminishing Role of Facts and Analysis in American Public Life by Jennifer Kavanagh and Michael Rich, which has as its focus, as the title implies, trends in public discourse in the United States. The extent of this phenomenon of truth decay may vary from country to country, but is one that must be taken extremely seriously. Kavanagh and Rich outline 4 trends that they argue characterise truth decay in the United States over the past 2 decades. And remember, this was written in 2018, and you can draw your own, have your own view about whether the decay has continued or increased in the years since its publication. But the 4 characteristics were these. 1, increasing disagreement about facts and analytical interpretations of facts and data. 2, a blurring of the line between opinion and fact. 3, the increasing relative volume and resulting influence of opinion and personal experience over fact. And 4, declining trust in formally respected sources of factual information. I'll come back to that 4th point in some detail. One matter to be flagged at the outset, and one consistent with the trends outlined by Kavanagh and Rich, is the corrosion of notions of objective truth and the dispassionate ascertainment of the facts, a topic upon which Henry Ergas recently wrote in The Australian. Concepts such as, quote, my truth, unquote, or a particular person's truth are often morally problematic, self-serving, and often defiant. Words and phrases such as, quote, misspoke and alternative facts also evidence the vice of relativism in this area. They often seek to mask or excuse what is simply dishonest. One might also observe that the rhetorical power of the concept of truth is subject to what one might think is cynical and strategic appropriation, as seen, for example, in the establishment of Truth Social as a media platform whose claim is, and I quote, to encourage an open, free and honest global conversation without discriminating on the basis of political ideology, unquote. The 4th trend identified by the authors of Truth Decay, namely declining trust in formally respected sources of factual information, may be seen in a judicial context by reference to recent experiences in the United States. I refer to the fact that notwithstanding the myriad superior courts, including appellate courts in the United States and courts comprising judges nominated by both Republican and Democrat administrations, notwithstanding that myriad courts have categorically rejected the claim that the 2020 presidential election was rigged or stolen, Many, many millions of American citizens apparently continue to give credence to this narrative. Putting aside that some cases which turned on technical questions of standing, the uniform dismissal of these cases entailed the conclusion that there was no truth to the factual allegations of widespread voter fraud. The apparently continued widespread acceptance of the narrative, despite its judicial rejection and overwhelming judicial rejection, means that a significant percentage of the US population is either ignorant of the rulings of multiple courts of high standing or simply do not accept such rulings as factually accurate or reflective of the truth. Neither explanation is comforting. The latter explanation is particularly disconcerting to a sitting judge, albeit in a distant jurisdiction and with a different tradition of judicial appointment, because it connotes a lack of respect for the work of the courts in reaching conclusions based upon the evidence or, in those cases, the lack of it. As a general and trite observation, any decline in trust of and respect for the decisions of judicial institutions is a matter of note and profound concern. To the extent that the courts are viewed as, quote, sources of factual information, the fourth trend pointed out by Kavanagh and Rich in Truth Decay in relation to declining trust in formerly respected sources of factual information focuses the mind and provokes thought about how such a trend may be resisted and reversed. Before turning to that topic, let me say a little about the relationship between the courts and their work and the ascertainment of truth, or the truth. On the face of things, there is a close association between the work of the courts and the ascertainment of the truth. Thus, witnesses must swear to tell the truth, the whole truth, and nothing but the truth. Professional conduct rules for lawyers require prosecutors, for example, to, quote, fairly assist the court to arrive at the truth, unquote. And lawyers are also obliged to assist investigative and inquisitorial tribunals fairly to arrive at the truth. This is the language of the professional rules. Further, lawyers, in the discharge of their duty to the court and to the administration of justice, must not engage in conduct that is dishonest and must not knowingly or recklessly mislead the court, nor make false or misleading statements to an opponent. Lawyers must not advise witnesses to provide false or misleading evidence or coach witnesses about which answers they should provide to certain questions. They must also refuse to take further part in cases where, to their knowledge, the client has lied to the court, falsified documents, or suppressed material evidence for which there was a duty of disclosure. Consistent with these strictures on practitioners, as Lord Denning put it, the primary duty of the courts is to ascertain the truth by the best evidence available. In the law of defamation, as I've already explained, the courts may be expressly tasked with ascertaining the truth, or at least what is referred to as the substantial truth, when a defence of justification is relied upon. But this is only one such example. This year, apart from marking the 200th anniversary of the Supreme Court, marks the 50th anniversary of the passage of the Trade Practices Act, a piece of Commonwealth legislation. This transformative consumer protection statute contained a provision, section 52, that proscribed conduct that is misleading or deceptive or is likely to mislead or deceive. Critically, for present purposes, that statute is not directed solely towards intentionally deceptive conduct, but operates at an objective level. In other words, if a statement or representation or conduct is inconsistent with the objective truth such that it is misleading or deceptive, the courts will impose a remedy, and it might be a corrective order where a representation has been made, for example, in advertising about the qualities of a particular product, or it might sound in damages as a sanction for conduct which is misleading or deceptive, i.e. Conduct which is not consistent with a true claim. To borrow the language of legislation currently before the Federal Parliament, that Act is concerned not just with disinformation. Now, disinformation is deliberately false information, but also with misinformation, that is objectively false information. That's objectively false information irrespective of the information provider's subjective intent. So somebody might make a statement which is objectively untrue, that is misinformation, and there will be a remedy, or there may be a remedy notwithstanding the lack of any subjective intention to misinform. Section 52 of the Trade Practices Act, which continues in the Australian consumer law and in the corporations law and various state and territory analogues, has resulted in Australian courts being placed in a role of peculiar responsibility for policing conduct that objectively deviates from factually accurate or true positions. From an early stage of its history, the legislation has necessarily involved the courts in the ascertainment or identification of the true situation or circumstances. Putting aside this particular legislative regime and returning to the topic more generally, equivalence between truth and the objectives of a mature judicial system is neither absolute nor coterminous, and there may be a difference or a degree of difference in this regard between our adversarial system of justice, the common law adversarial system, and judiciaries in the civilian tradition whose focus is on inquisitorial justice. So in our system, a case is determined by reference to the evidence the parties put before the court. In the continental civilian system, it is for the judge to make his or her own inquiries to determine the facts, the relevant facts relating to the particular question at hand. While it is the case that in the eyes of the public, a primary function of a contested trial, if not the primary function, is to conduct a search for truth through the mechanism of the adversarial system, this is in fact something of an oversimplification of the role of the courts. In the adversarial tradition, the objective of the judicial function is not necessarily to find the truth in all cases or at all costs. The fact-finding objective is balanced against other equally important or competing considerations, often derived from what are called exclusionary rules of evidence, some of which exist to serve policy objectives extraneous to the pursuit of truth, such as, for example, the need for finality in dispute resolution and procedural fairness, or by considerations which are informed by appreciation of the imperfections of human nature and human memory. Jim Spiegelman recognised that at times the untrammelled search for the truth may impinge upon other public values. He wrote, "The task of fact-finding for the courts is to identify the truth subject to the principles of a fair trial and to specific rules of law and discretions designed to protect other public values which on occasions are entitled to recognition in a way which constrains the fact-finding process." He gave as examples rules of evidence which may result in potentially relevant evidence not being taken into account or received by the tribunal, such as restrictions on the admissibility of fresh evidence on an appeal as evidence which has come to light after the hearing. That's not always admitted because it might come into tension with principles of finality of dispute resolution. Restrictions on the use of tendency or coincidence evidence. It might be relevant, it might point to a particular matter, but it may be overly prejudicial in terms of an ability to meet it. The exclusion of hearsay evidence, that's second-hand or third-hand evidence which may well be relevant but is not as secure, not as securely founded in terms of its reliability. The exclusion of lay opinion evidence. People can't just give evidence about what they think. They have to either be qualified or their opinion of what they think has to be based on something they actually saw or observed, not just their opinion of what happened. And so the quest for the truth in my day-to-day work and the day-to-day work of the courts has constraints, legitimate constraints, but which mean that the exercise, the process, is not without limitations and constraints. as Professor Twiney observed, the pursuit of truth as a means to justice under the law commands a high, but not necessarily an overriding priority as a social value. And Chief Justice Gageler, Chief Justice of Australia, has recently reflected on the historical and philosophical interrelationship between the concept of truth within the common law system and the concept of justice and the rule of law. What he said was this: the rule of law postulates the existence of a legal rule and postulates imposition of a legal sanction for breach of that legal rule. The link between the rule and the sanction is the fact of a breach. Whether or not there is a breach of the rule is a question of fact. Maintenance of the rule of law is dependent on the ability of our system to generate reliable findings of fact. Our legal system needs to be able to determine with integrity, in respect of a past event, the occurrence of which is contested and the occurrence of which is uncertain, that the event either happened or did not happen, or more accurately, is either proved to have happened or not proved to have happened. To the extent that the judicial process involves the pursuit of truth in the course of the administration of justice, the particular kind of truths ventilated in courtrooms tend to be highly specific to the parties to the dispute, although they may involve from time to time matters of great public interest. For example, whether there has been an abuse of power by a public official or misconduct, for example, by law enforcement officers, matters of concern to the particular party who may have been falsely imprisoned or wrongly arrested, but the ascertainment of the facts in that case are of interest to citizens because they will know that the courts are ascertaining by admissible, reliable evidence whether there has been a deviation from proper conduct. To reach that conclusion, a factual inquiry as to what actually happened, what the true position in a contested situation is a matter of general importance. Similarly, we know from some recent high-profile defamation cases, the Robert Smith case and the Lerman case, both of those cases of defamation were answered by findings of the establishment of substantial truth as a defence in relation to the otherwise defamatory matter. And those findings were, of course, of interest and of importance, not just for the parties to the case, but more generally. Thus, although some high-profile litigation may touch upon social issues about which there is intense factual disagreement, the role of a judge in most cases rarely involves reaching conclusions about wide-ranging truths of application to the community as a whole. Rather, a judge's typical role is only to find the facts necessary to resolve a particular dispute between the parties. Nonetheless, I would contend the court's quest for truth on a day-to-day basis is an important element in the courts, the institutional significance of the role of courts, and institutional significance lies in the community's confidence that there is a body of independent judges whose role is to identify and ascertain true facts when in dispute and then apply the law to those factual conclusions. So to the extent that the courts are viewed as arbiters of the truth, however narrow, or as sources of factual information more generally, the fourth trend pointed out by Kavanagh and Rich in Truth Decay in relation to declining trust in civic institutions focuses the mind upon whether there is in fact a decline in trust in our courts in Australia, and whether or not that is so, what can be done to anticipate, resist or reverse any such trend. In Australia, during the Law Reform Commission's 2021 review of judicial impartiality and the law of bias, the Commission conducted a survey which indicated that in 2020, trust in Australian courts had actually increased over the previous 10 years and was higher than trust in federal parliament, business and industry, and the news media, second only to university research centres amongst the bodies surveyed. Evidently, notwithstanding the frequent and at times unwarranted public attacks on the judiciary, there is, and I quote, quoting from Justice Beach Jones, a large reservoir of respect for the fairness of the courts. There is, however, no room for complacency, and as explained below, as I will explain below, courts have real vulnerability to the pernicious effects and reach of truth decay. A more recently reported survey tells a different story. On the 30th of July this year, the Sydney Morning Herald reported a Resolve Political Monitor survey of 1,600 people to the effect that only 30% of Australians have faith in the country's courts and judicial system, with 47% apparently responding that they had no faith in the judiciary, with 23% declaring that they were undecided or neutral, a sort of radically different picture to the Law Reform Commission's survey of 4 years prior to that. There may be a variety of reasons for erosion of trust in the courts, if that survey is correct, and they may be irrespective of a more general trend of so-called truth decay in our society. But to the extent that there has been or is an erosion of trust, it may contribute to the phenomenon of truth decay and a further diminution of respect for what should be the authoritative and respected fact-finding role of the courts in our community. Now, several features of our courts and the judicial system provide some form and degree of insulation from the corrosive effects of truth decay. In the common law tradition, judicial method itself involves an analytical, Socratic approach that necessarily prioritises fact and reasoned analysis and requires the balanced consideration of arguments in favour of and against a position before a final conclusion is reached. Extensive rights of appeal are also directed to the correction of both factual and legal error. Judges are also expected to retain at all times their independence and impartiality, such that their conclusions are not subjective or personal, but the consequence of their best endeavour to apply an external standard. Now, courts are also, to some degree, shielded from truth decay by the sometimes painstaking strictures of courtroom procedure, the ethical rules to which I've already referred, and the rules of evidence. For example, the opinion rule draws a strong distinction between evidence of facts and evidence of opinions and only allows for the admissibility of opinions in certain narrow circumstances, including where those opinions are given by experts with specialised training or experience and who support their opinions with reasoned analysis. The stringent requirements of procedural fairness, which is a feature of our courts, principally the fair hearing rule and the rule against bias, also have important work to do in ensuring that the courts remain a respected source of factual and legal information, the outcome of whose determinations has not been distorted by procedural irregularity. On the other hand, the ubiquity of social media and informational tools such as Google is increasingly prompting concerns about the integrity of the fact-finding process in jury trials. Modern jurors have in their mobile phones and other devices access to a vast volume of information which is not in evidence in a case and which may or may not be accurate, but which, notwithstanding judicial directions not to do so, they will be tempted to draw upon to discharge their responsibility as jurors. The juror is the ultimate determiner of the facts in all criminal cases, or most criminal cases. This is an increasing problem, corrupting the role traditionally played by jurors in the determination of the facts. A recent amendment to the ACT Juries Act has created a criminal offence for a juror to make an inquiry, including by conducting internet research for the purposes of any matter relating to the trial in which the juror is participating. And the point I've just made is a fortiori when one considers the power of artificial intelligence and the availability of artificial intelligence on everybody's iPhone. That is the role of artificial intelligence in this area is a whole separate lecture from which you'll be spared. Maintaining confidence in the work of the courts is another antidote to truth decay. The efficacy of judicial institutions inevitably depends on the confidence of the public and of other branches of government. Among public institutions, the judiciary is the most dependent upon habitual conformity to its decisions on the part of the community and the other branches of government. That habit of conformity only exists because the public have a certain attitude towards judicial power and those who exercise it, an attitude described as confidence, so confidence in the courts. When this habit of conformity disintegrates, the consequences can be calamitous. I turn again to the United States and the year 2000, when the outcome of the presidential election turned on a 5-4 majority decision of the United States Supreme Court in the case of Bush and Gore, the case about voting in Florida. Al Gore, after that decision was handed down, ordered his supporters, or said to his supporters, quote, "Don't trash the Supreme Court." The outcome was largely accepted without violence or social unrest. A year and a half later, on this side of the Pacific, Chief Justice Murray Gleeson would remark, "Doubts about the electoral process were resolved by recourse to law, and the nation accepted the result. Dissatisfaction with the outcome on the part of about half of the voters and criticism of the decision of the court coexisted with peaceful acceptance of the consequences of the decision." Now, there's an obvious contrast with what occurred 20 years later in the presidential election to which I've already referred, and that also corresponds to currently reported historically low trends of public confidence in the United States Supreme Court. Within the US, you've probably seen reports of that. It's now down to around 30% on a variety of surveys. At the same time, there have been strong attacks on judges of lower courts who've been described as tyrannical and unhinged, radically left, so-called judge, corrupt judge, etc. And that kind of language in the public discourse about independent judges inevitably corrodes respect for the role of judges in our civic society and has consequences for the respect for the decisions they make. So attacks on the judiciary are far more than attacks on personal or individual judges. They erode confidence in the courts as a whole. There is some irony in that the branch of government which was described as the least dangerous by one of the architects of Western democracy, Alexander Hamilton, is often treated by modern populist movements across the world as if it were the most dangerous branch. The irony is perhaps best explained by Professor Wojciech Sidursky at the University of Sydney, internationally renowned philosopher, legal philosopher, in a recent book surveying illiberal populism and constitutional turmoil in various democratic countries. He writes, and I quote, "The same factors that render judges and courts the least dangerous branch at the same time make them the most defenceless in the face of executive assault. After being elected, populist rulers almost invariably take on the courts, often with fervour and unusual animus." Professor Sidursky offers two related reasons why attacks on independent judiciaries occupy such a prominent place in the ideological agendas of populist movements. First, they offer the most feasible, that is, the courts offer the most feasible alternative legitimacy to popularly elected leaders by providing a channel for citizens airing their grievances against governments. And secondly, the existence of any independent check on the will of the people is incompatible with populist ideology. Therefore, in the eyes of the populists, members of the judiciary become anti-democratic elites. To this may be added the practical reality that populist leaders tend to be elected on ground platforms of anti-establishment social or institutional reform, proposals of the kind that are likely to engage the close scrutiny of constitutional courts, particularly where they touch on civil liberties or involve attempts to alter the structure or powers of state entities and or compromise judicial independence. So truth decay in the context of the work of the courts will only be hastened by attacks on independent judiciaries and judges. It is incumbent on courts and the legal profession more broadly to develop strategies for maintaining confidence in their vital work and resisting or at least mitigating the erosion of rational, fact-based public discourse. Extensive civic education about the role and importance of an independent judiciary is critical, and that has been the key focus of the Supreme Court of New South Wales bicentennial celebrations this year. But much more than that is required. The vulnerability of the courts to misrepresentation and unfounded criticism raises age-old questions about the role of the judiciary in public debate. In particular, it raises questions about what body or office is best placed to defend the courts against inaccurate or unfair criticism, and whether or in what circumstances courts should publicly correct the record. Much has changed since the days of what were known as the Kilmer rules, which are in fact not rules at all, but a letter written in 1955 by the Lord Chancellor of the United Kingdom to the Director General of the BBC, in which Viscount Kilmore said that as a general rule it is undesirable for judges to broadcast on the wireless or appear on television. It is now accepted that judges may be contributors to public discussion, provided that they are always careful not to attract controversy or undermine the independence or dignity of their office. Within these overriding constraints, the freedom of judges to contribute to public discussion is reflected, for example, in the UN's Basic Principles on the Independence of the Judiciary and the Australian Institute of Judicial Administration's Guide to Judicial Conduct. Yet the prevailing tendency remains for judges to be reticent to engage in public commentary. The more specific question which arises in the context of the present discussion is this: against a background of possibly an erosion of trust in and respect for reasoned, factual public discourse, what role do judges and courts have to play in responding to or correcting inaccurate, ill-informed public criticism of their work, other than through the judgments they issue? In the age of digital platforms on which misinformation can spread at lightning speed unless swiftly countered, should the judiciary take a more muscular approach to defending itself from unfair criticism? These questions should be considered against a background of shifting political norms involving the role of the Attorney General of any particular polity as traditionally the defender of the judiciary, even when criticised by his or her cabinet colleagues. The increasingly belligerent criticism of judges towards the end of the 20th century also coincided with a well-observed contraction of the willingness of many Attorneys General to defend the judiciary in the political arena and the public domain. So modern judges can no longer expect that an Attorney General will leap to the defence of the courts, particularly where doing so would involve criticising cabinet colleagues. Over past decades, courts have developed a number of strategies to preempt and respond to ill-informed public commentary. First, from the 1990s, courts around Australia began to appoint public information officers tasked with publicly communicating the work of the courts to the journalistic profession and facilitating requests for information. And it's since become routine for courts to issue judgment summaries in cases of particular public interest or complexity, with the primary goal of assisting journalists to report accurately under the deadline-driven, time-poor conditions of modern journalism. And in the past decade, courts have begun to use the internet to speak directly to the public by live streaming certain high-profile court proceedings and posting judgments and judgment summaries on social media accounts. On the whole, I should say, I believe that the live streaming of cases of public importance to be a valuable and a natural extension of our general commitment to open justice. Such streaming will demonstrate to the public the nature of judicial work and, in the delivery of judgment, the natural sifting of evidence and systematic, structured and careful working through of arguments to arrive at what will be taken to be a true conclusion, the conclusion about what actually happened before one reaches the legal consequences based on that determination. Care must, however, be taken where possible to avoid the sensationalisation of these solemn hearings. The question of when it will be necessary or indeed helpful for a head of jurisdiction to issue a public statement to correct the record is a very delicate one. The guiding consideration should always be whether the criticism has the capacity seriously to undermine public confidence in the court, and whether a public statement will in fact mitigate the damage or merely compound it. There is always a risk that by responding directly to unfounded criticism, the dominant effect will be merely to amplify that criticism. One must always also be conscious of the likelihood that the statement will be conveyed back to the public under sensationalist headlines such as "Court hits back at Minister," unquote, and one finds oneself in a public debate. As with many decisions that fall to judges, this is an area where there are no hard and fast rules. A decision has to be made on a realistic assessment of all the circumstances. A statement by a head of jurisdiction is most likely to be the appropriate response where an unwarranted attack is mounted against the competence of a particular court as opposed to the court system as a whole. In this context, it should be noted that attacks on the judiciary do not always take the form of criticism of particular decisions or perceived patterns in judicial outcomes. They may also take the form of unfounded criticism of a particular court's competence, including its accessibility to the public, the efficiency and expense of its processes, and the expertise of its judges. As for steps that judges may take to encourage factual, reasoned debate about the courts and their decisions, attention should also be given to other ways in which courts and judges may proactively promote broader public engagement in and respect for the work of the courts. So in conclusion, the concept of truth decay is an arresting one. An element of it is bound up with a deterioration in respect for institutions which have been traditionally associated with authoritative fact-finding. The courts are such institutions. While the ascertainment of truth does not represent all of the work done by courts, it is nonetheless an essential and important component. Maintenance of respect for the work and independence of Australian courts is important for many reasons. One of those reasons is to preserve the notion that truth is not relative, and its ascertainment is the foundation for many, many legal outcomes of significance not only to the parties in the immediate case, but also at a more general level of institutional importance and respect for the rule of law. Thank you very much.
Chief Justice, thank you very much indeed for that very searching lecture. I'd like to begin with a point that arrested me, caught my attention, the low levels of faith that you recorded, or the Sydney Morning Herald reported, that you referred to from July, and then comparable figures in the United States. And this loss of public confidence in the judicial system, and the point that you made about confidence being related to public sentiment, seems in many ways to be related to the issue of sentencing. And I'll take an example from another jurisdiction, in England, the case of Lucy Letby, who's been convicted of multiple murders of babies. She's been given a whole of life sentence, but now there is a question about the validity or the accuracy of the statistical evidence that was used to convict her. And the questioning of, or the very fact that statisticians are questioning the quality of the evidence has provoked a real outcry amongst victims and their associates. To what extent do you think the matter of sentencing, particularly in criminal trials, is largely responsible for this collapse in confidence, that people feel that those who are convicted should pay the price, they should get what they deserve, and if courts don't do that, if they don't give what the public thinks people deserve, then confidence in the judicial system collapses. Is sentencing a large factor in this, do you think?
Sentencing and criticism of sentencing was certainly a very big issue. It has been a very big issue in the last 10 to 20 years. Often, not always, but often the media criticism is alarmist and not informed by the actual evidence on sentencing that is placed before the judge, who has the difficult task of sentencing. Judges are required by statute to take into account a whole range of factors. Sentencing is not solely about punishment. That's obviously a core element, but it takes into account a whole series of factors, including subjective circumstances. So it's very easy, particularly in highly emotional cases, for often shock jocks to go hard on a particular sentence. But often, if he or she was familiar with the underlying evidence and the various steps a judge was required by legislation to step through in reaching a sentence, the criticism is not founded, or is not as well founded as is presented in strong and emotive language in the press. Very interestingly, the Chief Judge of the County Court of Victoria, Justice Peter Kidd, and the County Court of Victoria and the District Court of New South Wales do the bulk of criminal work in our court system in terms of volume. He has taken, and has done this for many years now, to regularly appearing on various radio programs to explain sentences and to explain the sentencing process. And that has had quite a salutary effect in not eliminating but mitigating the alarmism which often follows. And it's actually quite a good example of what I was talking about what the courts can do, in a sense, by a public outreach, or what heads of jurisdiction can do by a public outreach to educate the public about the complexities of particular aspects of the judiciary. Another thing we do in a lot of our cases is to issue what are called judgment summaries. We have to give detailed reasons for our decisions. They might be 20 or 30 pages, they might be longer. Increasingly, media have fewer and fewer journalists who follow the work of the courts, and they simply do not have the time, given the volume of the work of the courts, to work their way through 30-page judgments or 50-page judgments, etc. So we produce what are called judgment summaries, which don't form part of the judgment but are presented as an accurate summary of the facts, etc., to encourage accurate, responsible reporting about decisions, including contentious decisions. But certainly sentencing, bail decisions is another example, which is regularly given a run and one has terrible tragedies like the one we had in New South Wales recently, where a woman was killed by someone who was on bail. But bail is, the decision to grant bail is a risk assessment. That's what it is. A judge has to make an assessment about whether a person pending the hearing of the charges against them should spend that time in jail before they've been convicted, and irrespective of the fact that they might not be convicted, and balance that against their risk of offending while on liberty, and whether there are conditions which can be imposed which allow someone to remain in the community but subject to reporting requirements. Now, subject to ankle bracelets is the new proposal. But at the end of the day, it's a risk assessment. It's genuinely made by very conscientious judges, but they are not Nostradamus. You can never know what someone who is on bail will do. The tragedy we saw recently was a tragedy, but there are thousands of people on bail pending their trial who do not offend and whose liberty is not restricted pending a determination of guilt by their peers, by a jury of their peers. And so these are the delicate issues which can affect confidence undoubtedly can affect confidence in the jury, in the judiciary, because politicians will tend to get onto the media bandwagon and say, yes, we've got to make bail laws, we've got to we've got to make bail even harder to get. Well, that's a political prerogative, but what it means is that unless there's a huge investment in courts and judges, there is inevitably a backlog, because we have a finite number of courts, we have a finite number of jury rooms, we have a finite number of judges. There are only 300, just over 300 judicial officers in New South Wales, including magistrates. We have a population of over 10 million. Not every case can be heard immediately. And so these are the difficult issues. But within that constraint, which we have to be, it's a reality, part of my role and the role of some of my senior colleagues is to explain the situation, so we don't just have attacks on the judiciary which are left unanswered.
Thank you. Let me ask you about another area of law that you touched on, the law of defamation, where and you referred to two very high-profile recent cases, there seems to be a shift away from bringing a defamation action because of reputational harm, and it seems to be more the case that people sue for defamation because their feelings have been hurt. Is that accurate, do you think? I mean, that's the popular perception. Someone will sue because they've had their hurt feelings. And if that is accurate, how does the law of defamation need to be reformed to keep pace with the digital age in which, opinions, as you've said, are easily and widely dispersed?
Yeah, I don't think I agree with the premise of your question. There has to be a defamatory imputation. It's not just somebody's hurt my feelings. It has to be demonstrated that what is said or written diminishes that person's presumed good reputation in the community by virtue of the publication. So I don't think defamation is driven by that. There is, of course, what we've seen recently with the two unsuccessful defamation suits is hardly new. Happened to Oscar Wilde. It's happened in the UK often. There's this great history throughout the English common law or the Anglo-Australian common law of people who've had success in being acquitted or escaping some prosecution, and then becoming confident and aggressive and think they'll bring a defamation suit, and it's all unravelled. Happened to Jeffrey Archer. You can pick out examples through history. I mean, I wouldn't advise anyone to embark on a defamation.
Going back for one's hat,
yeah.
as the judge put it in the 11 case.
Yeah.
So one aspect of the issue of truth decay, which confronts the judge, is the empirical verifiability of truth claims about facts, and those claims are tested by the court. So we know there's a relationship between truth and verifiability. What about the relationship between truth and morality? Can something be true in the sense in which you are using the word true or truth, even if it's unsupported by empirical evidence?
The law in that area of the Trade Practices Act and analogues misleading deceptive conduct, notions of truth are nuanced in the sense that somebody can make a statement which is literally true but contextually untrue, or half-truths. So half-truths can be treated as misleading or deceptive. I'm not sure if that's necessarily dealing with what you were getting at, but most law, my sort of general view after 40 years in the law, studying and practicing it, is that most legal principles are directed to a just, fair outcome. It's as simple as that. Most cases don't involve arcane questions of law or legal nicety. Most cases are fights over the facts. That is what the vast majority of cases are about, and what courts determine. It's not, legal academics sitting around making fine distinctions. So that the general thrust of our work is seeking to get to the truth of the matter where parties can't resolve disputes for themselves. And it's often difficult, those disputes which can occur in the criminal law and the civil law, where you have a he said, she said argument, or where there are only two parties to a conversation which wasn't recorded, and where the parties are at odds. Judges have to determine what happened to the best of their ability. And we have techniques of doing that. So we look for, we analyse conduct which happened. We analyse the plausibility of, is something likely to have been said given what else we know based on documents, for example, documents before and after. We look for reliability. There are sort of techniques for testing truth. Cross-examination is designed to rigorously but fairly test a particular witness's account. So all of the features of our mechanics of litigation are directed to resolving that. And then appeal rights include, from not all cases, but many cases, there's an appeal on the facts. And Australia, New South Wales is different to England, for example. You only get a right of appeal in England on a question of law. You have a right of appeal in New South Wales to the Court of Appeal without needing leave. You can get it on a question of fact in England with leave, but we don't have that threshold requirement. So that's all part of this particular state's approach to judicial determination.
You referred also to the legislation before the federal part, the Commonwealth Parliament, on the misinformation, disinformation issue. Both, and the government seems to want to address the issue of hate speech, including vilification and incitement, but also to bring greater pressure to bear on tech companies. Now, I know you can't take a political position on these matters, but can I ask you this? How can the legislature strike an appropriate balance between protecting individuals from harm on the one hand and protecting the fundamental right of free speech, which is so important for a healthy, open society? That seems to be a very difficult balance for a legislature to strike.
It is, and it's made more so because of the international dimension of information dissemination. I mean, the real, free speech is always subject to limitations. Defamation, the law of defamation, is an accepted limit on free speech. Hate speech is increasingly regarded as a limitation on free speech, which is legitimate. The challenge with hate speech is to strike the balance where you strike it. The law of confidential information and trade secrets, etc., are a restriction. Is a restriction on free speech. But the real problem, and so I don't think that a government is interested in seeking to ensure that misinformation is in the community. I don't think that's a radical thing. That's my point about the Trade Practices Act. We are concerned, have been for 50 years, with honesty and truth in commercial dealing and advertising, etc., as a rationale as consumer protection. And that as a policy goal is fine, and that is a restriction on free speech. You can't make false statements about the qualities of a particular product or a therapy or a drug or a pharmaceutical, etc. You just not allowed to do it. But the real problem with the current situation and is that a number of these huge disseminators of information do not have a physical presence or amenability to our jurisdiction. Right? They're operated offshore and they're insulated from, according to orthodox notions of extraterritoriality, they're beyond the reach of the legislature. Now, in another paper I gave last year, I've explored the shift. Traditionally, polities would not pass legislation which had an extraterritorial effect because that was seen as an interference with another sovereign state. But there's a big trend now towards polities passing extraterritorial legislation because they need to or feel that there's a strong policy reason to seek to regulate offshore activity which has an effect onshore. But a court or a regulator is only powerful if it can bring the regulated party to heel. And if the regulated party is not here and doesn't have assets here, but whose information circulates here, that's the real challenge, which is very interesting. It's a real shift and challenge for regulators and legislators as to how to resolve it. But the two concepts of disinformation and misinformation, I mean, this is really just expressing a personal opinion. I don't find it at all surprising that a government would want to regulate that to ensure that our public discourse is polluted with misinformation and disinformation.
Thanks. Let me ask you about the bicentenary, a very significant anniversary that the Supreme Court celebrated this year, which you have remarked upon and played a leading part in, of course. And you touched on the relationship between judicial officers and various attorneys general. Separation between judicial and executive authority in the early days of the colony was slender, and you touched on this, and that the governor had considerably more power then than he or she does today. How has that relationship between the executive and the judiciary changed over those 200 years? And what, if any, sources of conflict between the two do you see in 2024 and the years beyond? In other words, what were we talking about for the 300th anniversary?
Yeah, well, we make decisions from time to time, as say the New South Wales Court of Appeal, just as the High Court makes decisions from time to time which are not popular with government. So certain decisions in relation to migration, which have been made by the High Court, caused political strife for the Albanese government just over a year ago, and there are other examples predating that. And at a state level, we have made decisions which are in relation to state legislation or regulation, or indeed authorities, which have resulted in either legislation or regulations being struck down, or significant penalties being imposed on. Now, in a mature democracy, those decisions are respected. And as I pointed out during my speech for the bicentenary, happily in Australia, we have had that respect, notwithstanding that the decisions are unpopular for governments. So that is good. That is a good story, and that has been, by and large, a continuing story. In the 1930s, the New South Wales Court of Appeal struck down legislation which would have abolished the Legislative Council. So there was actually an attempt to get rid of the Legislative Council. Such an attempt had succeeded in Queensland about 10 years before, and that's why Queensland is a unicameral. But the same approach was taken by Jack Lang, but our court struck that down. It was upheld in the High Court and then by the Privy Council. So we do have flashpoints where there are cases which bring the arms of government into some conflict. We had, during COVID, challenges to various health COVID regulations. As it happened, we upheld those, but the argument was that they were invalid and we had to rule on them. In terms of tension, one of the vulnerabilities of the judiciary is it relies on the government for its funding and for its resources and for appointments. Now, we have had a good tradition of non-political appointments, by and large, to our courts, and appointments which are of good people who become good judges, etc. We don't have a tradition in this country of the stacking of courts as occurs. We have security of tenure. Mexico has just got rid of their judiciary and appointed a brand new judiciary. That's not a good thing. If I can put that as simply as that. But we do rely on funding. I mean, our judicial salaries were frozen without notice or consultation 2 years ago. We hope that freeze lifts, but at a time of high inflation, unless that freeze is corrected, that represents a 10% reduction in the real wages of judges. So we're vulnerable to that. I'm making a point of principle. I'm not crying poor, but I am making a point of principle. You want your judges not to be dependent on things like pay rates, etc. You want that to be independently determined. You want it to be maintained, not just for reasons of the status of the position, but it's all part of security of tenure. You know, and just as, you know, I would make the same argument for political pay. I think politicians should be paid better than they are to, apart from anything else, eliminate the risk of corruption or the temptation of corruption. So anyhow, that's just a general observation. But the hopefully we will continue to have a situation where governments of all political persuasions recognises the role of the judiciary and the importance of an independent judiciary. And one of the messages I have been promoting throughout the bicentenary is to promote an understanding of the important work of the courts that they do and the importance of their independence and the importance of maintaining respect for that work as just a part of our civic society.
One final question from me, and then we'll go to questions from the audience. You mentioned COVID. You were sworn in as Chief Justice in 2022 in the middle of the COVID pandemic. Well, I'm not sure where the middle was, but it was certainly during the COVID pandemic, such a serious challenge to our society. What were the immediate, and this is sort of a personal question really, what were the immediate challenges that you faced in your new role, and what do you think the judiciary has learned or needs to learn from the pandemic, these exceptional circumstances?
Well, my philosophy, and it was quite a deliberate approach I took, was towards we were coming out of the pandemic, but there had been this massive shift. People had been working from home and were used to working from home, and there was still nervousness, etc. But I strongly promoted people coming back in to the city and working with each other in the profession. I described the effects of working from home, and this wasn't universally popular, this view I took, but I described it as the insidious depersonalisation of the law and the legal profession, where people were not having genuine personal interaction. So they would meet on Zoom or Teams. At the end of it, you'd press a red button. There was no incidental conversation going back to the office or going back or walking up to court. Junior people weren't able to ask their seniors informally, well, what was all that about? They'd have to physically get in touch again in a non-natural way. And I was very concerned that what was a temporary depersonalisation or a temporary dislocation of genuine personal interaction could harden into something more permanent. And my own view was that would be very bad, because I take the view that the legal profession should be collegiate, should interact, and legal issues it's all about understanding people and engaging with people. Now, I wasn't intending by that to say that there weren't some advantages from flexible work arrangements, etc. There undoubtedly are. And the courts certainly shifted to the use of more technology, which is okay to some extent. But I was genuinely concerned that there'd be less and less engagement. I just think that's not how humanity is designed to integrate, to operate. So I pressed that quite deliberately and quite forcefully, and we've seen a pretty good return. And I think most people are pleased to be interacting in a real way rather than this artificial, removed way.
Thanks. Thank you. Questions for His Honour. Professor Benson.
Thanks very much for your address. Apropos COVID, the bigger issues weren't the disconnection of people from their offices with respect. It was the coercive mandatory vaccination approaches, which were inconsistent both with the Nuremberg Code and with the Syracuse principles. I think our courts have lost a great deal of respect because they didn't put the feet of the health ministers to the fire with respect to what were really gross infringements of fundamental freedoms.
Well, we had arguments to that effect. There were cases to that effect in New South Wales and cases in which I sat with some colleagues. We took a different view about that. There are arguments about whether they were justifiable temporary measures. People I fully understand, have different philosophical views about that. We took the view that they were not unlawful, and we gave a reasoned decision which people are at liberty to accept or reject. But as I say, that is in a sense, the type of work we do. We give our honest, genuine view of it. We're analysing it legally. That was a question about power, whether there was power to make temporary regulations which required vaccinations or various measures which restricted liberty. But there was a trade-off involved which we held was lawful. That's just the reality of the situation. But I fully respect that not everyone would necessarily accept that decision, and people's views philosophically don't always accord with the legal position. We expressed a view based on our understanding of the law and the extent of governmental power.
Thank you. There's a question at the back.
Yes, hi,
yes.
Your Honour. Yes, I just want to ask a question in relation to the judgments and the confidence in the judgments. Do you think that some of this is to do with the fact that judges often time poor, relying on associates and researchers to give them information that isn't necessarily time? They haven't got time limits to actually look at the correctness of all of that. And I won't name any courts, but sometimes what's actually filed in a court in evidence isn't what's before the judge on the day. So do you think some of this is actually some of the court systems and the time constrictions on judges that could be affecting some judgments that people lack confidence in?
Yeah, no, I don't agree with that. I certainly agree that judges carry huge burdens, so a lot of work is done by a finite number of judges, and we work hard to get through the work as efficiently as possible, but consistent with doing it conscientiously. I mean, matters the judges, certainly in my court, I have absolutely full confidence that they are making the decisions based on the evidence which they have heard and which they read, and the arguments. And if there's an issue with what they've done as a matter of procedural fairness or legal incorrectness, that can be challenged in the Court of Appeal, and it is from time to time, and the system has that safety valve. But it is undoubtedly the case that the volume of work expected to be done by a finite number of judges does put pressure on them. I mean, ideally, we would have more judges and we would have more courts. Ideally, judges would have more time to deliberate on cases. I mean, we have a situation where some magistrates have over 100 cases a day they've got to get through. Now, they're not all substantive cases, but there might be procedural hearings, etc. But that's a huge volume of work. But I'm not familiar with the issue you've identified. I mean, I'm not sure if you've got some specific cases in mind, but I certainly agree that having enough time to do the work is a trade-off between getting through the volume, etc.
Thank you. My colleague Warren Mundine at the back.
Yeah, sorry. I agree with a couple of things. I agree you'd have to be mad to go into defamation. I only did it once. I was forced into it. But and also a few other things I do agree with you. I want to get back to the trust, because you're right. The trust of the judiciary, the trust of the legal system, we're all benefactors of that, of having a civil society and everything like that. The concerns I have, and this is, as you probably know, I was a leading person in regard to the No campaign in the recent referendum. The concern I had was the legal profession in its structures, like the law societies and the bar associations that took a side in a political process. Now, individual senior counsels and individual lawyers can make their own decisions, but I'm concerned by that approach of actually having a law society and a bar association that come out so strongly on one side of the argument, because I'll be quite frank about it, that for the first time in my life it put doubt in my mind in regard to the legal profession.
Well, got to be. I obviously don't speak for the Bar Association or the Law Society. And perceptions of the legal profession are not necessarily the same as perceptions of the judiciary, but they can be blurred, and that may be part of what has happened. I don't. Obviously, I wasn't on the Bar Association or the Law Society. I'm not going to express an opinion about that. My concern is to uphold the reputation of the court, and make sure that the court is apolitical. Of course, judges are entitled to and have personal views, but it's very important for judges, and judges do, by and large, take the view that those personal views must be kept to themselves. We don't have, by and large, judges who will be out campaigning, and indeed it be contrary to the Guide to Judicial Conduct.
Thank you. We have time for one more question. John.
Yeah, just John Connor. I've had the experience of practicing in a number of parts of the world, principally in common law jurisdictions, but with some experience and exposure to civil law jurisdictions. One of the things that's really struck me over the years is the cost of civil litigation in common law jurisdictions is absurd. And in fact, it's a huge impediment to justice for most people. And I don't think that same there's that same imposition to the same degree in the civil law system. I put a good part of that down to our adversarial system, which is designed theoretically to produce the next to perfect truth. Having said that, I don't believe that the judgments that one gets in Scandinavia, Germany, the Netherlands, Switzerland, and some other places are in any way inferior or any less respected than our judgments in common law jurisdictions. Are you aware of any real study? I know Jim Spiegelman's done something in relation to a French court. I haven't had a chance to discuss it with Jim, but I doubt his conclusion. But are you aware of any real studies as to the comparative costs and therefore the benefits between the two systems?
I'm certainly very conscious of the issue of cost, but I'm not aware of certainly not aware of any recent study. We do have in New South Wales the Civil and Administrative Tribunal, which deals with a huge volume of civil disputes. And it's not a court, it's a tribunal, but it makes decisions which have binding effect. And at various levels, lawyers aren't permitted to appear. Other levels they can appear. And the statutory injunction to the Civil and Administrative Tribunal is with an emphasis on informality and minimisation of cost. And so a lot of people who are in dispute, where their disputes fall within the very broad jurisdiction of NCAT, the Civil and Administrative Tribunal, have their disputes resolved for relatively modest cost. Obviously, the more complex the dispute and the higher up in the judicial hierarchy, I agree, the costs are enormous. There have been some steps taken, for example, in relation to discovery, that's disclosure of documents, etc., to bring those costs down, and they have been effective, I think, to a large degree. But as to your specific question, an empirical study, no, I'm not aware of.
Thank you. Final question from Tony Burke.
Your Honour, thank you for a very thought-provoking speech. And one of the thoughts that a number of people have come back to is the confidence in the courts. Excuse me. And let's start in the United States, where it's really the confidence in the Supreme Court has gone way down, as you mentioned, and clearly one of the reasons for that is political appointments. And I think you made the point that that's less the case here, although I think there's been appointments to the High Court which have been criticised. And I'm pleased to hear that in New South Wales it tends to be impartial. But I imagine it's possible that in New South Wales you could have political parties who don't abide by that and make political appointments. What I'm wondering about is there an alternative, or what alternatives are there for appointment of judges?
Yeah, so in the United Kingdom, there's a body called the Judicial Appointments Commission, which was introduced just over 10 years ago. And so people have to apply to be a judge, including on the ultimate appellate court, on the Supreme Court of the United Kingdom. And there's an interview process. There is you have to make your case for appointment to the High Court or the Court of Appeal or the Supreme Court. And there was initially some hostility to that, but as I spoke recently with a member of the UK Supreme Court, and he says that hostility to that mode of appointment, he'd been at all three levels, in first instance that he had to apply each time. But he says that has there's less opposition, or it's accepted now, and so that is seen as more transparent. It all depends, or the efficacy of that depends on whether the recommendations of the Appointments Commission are then accepted by government. And I don't know if they've had a situation where what has been recommended hasn't been accepted. In Australia, there are different approaches taken in different states and in different courts within the same state. So the federal court now has something like an appointments process, but it's less structured, I think. But it is designed to it's designed to have a neutral or a politically free. But I don't think. But that's driven by transparency, a commitment to transparency. I don't think we would want to go down the US route where prospective federal judges appear before the Senate and are asked about their views and how they will vote on certain issues. I think that adds to the politicisation of the process, and the higher up the hierarchy in the US, because that's where the sort of civil rights issues will be determined, the more explicit is the questioning and the more explicit is the sort of interrogation. Just to give you an illustration of what it just reflects my view, I don't think a judge should ever appear after he or she's been appointed next to the Attorney General or the Premier or the Prime Minister at a press conference in the way that senior American judges, the notion that this is the President saying, these are my judges, it is completely anathema to the separation of powers. They're not the President's judges, but the perception that they are is only reinforced by. And so you will generally, I think, not see. So I certainly, when I was appointed, there was no press conference with the Attorney General or the then Premier, and I wouldn't have agreed to it. Same with Stephen Gagler in the High Court. Same with Tom Bathurst, etc. I mean, I obviously have to deal with government on practical issues like appointments and making recommendations for appointment and practical issues about the logistics of the structure of the courts. But we are very careful about perceptions in terms of, for the reasons I've given.
Thank you, Chief Justice. Thank you very much. For decades, the CIS has been a fiercely independent voice working hard to promote sound liberal principles. To be notified of our future videos, make sure you subscribe to our channel and then click the notification bell. We rely solely on the generosity of people like you for donations to advance our classical liberal cause. Check out the links on screen now to see how you can get involved.